In this courtroom, tension meets accountability. Miss Hawkins stands accused of driving while intoxicated, a charge that can carry up to 6 months in jail and a $2,000 fine. What began as a simple traffic stop quickly escalated when officers discovered she had parked on the wrong side of the road and admitted to being buzzed. The evidence paints a concerning picture. Bloodshot eyes, a strong odor of alcohol, and a plastic cup in the console still containing tequila. This isn't just another DWI hearing. It's a defining moment about judgment, privilege, and consequence. As we watch, the judge's patience and precision turn this ordinary case into a lesson in personal responsibility and public safety.
Good morning, Ms. Hawkins. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On March 6, 2025, at approximately 10:29 p.m., the officer observed a vehicle driving with expired registration as of March 2021. A traffic stop was initiated. However, the vehicle continued to travel down the feeder road until it turned and pulled onto the wrong side of a two-way road and parked facing northbound in the southbound side of the roadway. The officer made contact with the defendant, the driver and sole occupant of the vehicle, and observed the defendant to have bloodshot eyes, droopy eyelids, and a strong odor of an alcoholic beverage. The defendant admitted to drinking 1.5 alcoholic beverages, and the defendant stated she was buzzed but not drunk. An inventory search of the vehicle was conducted, and the officer found a large plastic cup that was 1/4 full of alcoholic beverage that smelled of tequila in the center console cup holder. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 3 out of 4. The defendant was read the DIC.
The judge's tone is calm but deliberate, making it clear that driving under the influence is a serious offense. When he declares sufficient probable cause, he is affirming that the officer's observations, erratic driving, visible signs of intoxication, and the driver's own admission provide enough legal grounds for prosecution. This moment marks the official transition from suspicion to certainty in the eyes of the court. It's not just about alcohol. It's about establishing accountability through evidence. Probable cause is the line between an allegation and a case that moves forward.
Refused to provide a specimen, a blood search warrant was signed and executed.
Are you telling me that she has alcohol in the car while she's driving?
It's just she had a cup of alcohol.
Ms. Hawkins, I'm going to find that there's sufficient probable cause to go forward with your case. I am now placing several conditions on your bond. If I find that you violate these conditions, I will revoke your bond, put you in jail. No more PR bonds, ma'am. You're not allowed to drive. I'm taking away your privilege to drive. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. This is an affidavit that you're going to promise to me that you're not going to drive. Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're consuming alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail, ma'am.
Judge, is that standard for driving?
She has alcohol in the car while she's driving. And so I would presume that it's elementary that you're not to have alcohol in the car while you're driving. It scares me, and I just don't want her driving for now.
The atmosphere shifts as the judge announces the suspension of Hawkins' driving privileges. His tone remains measured, but the message is unmistakable. Driving is not a constitutional right. It's a condition of privilege. By ordering her to sign an affidavit promising not to drive,
but it just seems
he
like
emphasizes
no driving
both
at all
control and
seems a bit
compassion.
harsh for a
It's
first
a
offense. You
preventive
don't even know what
measure,
blood is at this point.
not a punishment.
Get it?
The court is acting
But
not
she
out
has
of anger but
alcohol
caution,
allegedly in the car
reinforcing that
while she's
public
driving.
safety outweighs
One would
personal
presume
convenience.
that
In that
that's
moment,
a
the
humongous
courtroom feels less like a place of judgment and more like a
want
mirror,
her to
reflecting the
appreciate
real cost
the
of one careless
privilege it
decision.
is to drive. It's not a right. It's not a right. It's an absolute privilege.
Judge, if I may, what would be the conditions under which she's able to come back and get permission from the court? At what time frame?
I need to know that she understands and appreciates the privilege, be proactive. It's not forever, Aaron, but I want her to understand that it's a privilege. It's not a right. And it's something that people should take very seriously.
with the alcohol?
I don't want you to talk here now in front of him. You know, you guys at a later date can come back. I'm always all ears. Like, it's not
For
absolute.
Greg's purposes, since he's going to be the one representing her, what is a later date? I mean, is there something we can do? Because, you know, if it's something that you'd like her to do while on bond to make sure that she's, you know, addressing the issue, I mean.
Be creative, be proactive. I want to know that she appreciates it, and I'm all ears, you know? But it's something that I've seen more and more, you know, where there's alcohol in the car, and I would presume that you would know, especially at this age, that, you know.
Well, to be fair, Judge, the allegation is that she violated the law. The presumption is that you would know not to violate the law, period. I personally don't think that the fact that there is possible alcohol in the car, I don't think it's been tested, but it just seems like no driving at all seems like a harsh penalty for someone who's never been arrested before, no criminal history. These are allegations. There's a blood draw pending. According to the dim summary, she had 1.5 drinks. It's certainly possible her alcohol level comes back below.
As the defense argues for leniency, the courtroom dynamics become more intricate. Her attorney raises a fair point. A total driving ban seems harsh for a first-time offense, especially with no confirmed blood alcohol results. But the judge's response is resolute. He reminds everyone that the presence of alcohol in the vehicle changes everything. His decision isn't driven by emotion, but by principle. The courtroom learns that legal discretion isn't always about compassion. Sometimes it's about prevention. Through composure and clarity, the judge reinforces the purpose of the court, to protect lives before tragedy strikes.
The legal limit. And if that takes 90 days to get those lab results and come back and get this taken care of, she's not driving for 90 days.
I'm not saying that long, Aaron. I just want some kind of proactivity that I know that she appreciates. Come back and, you know,
And
hey, you know,
for Greg's purposes, so I can convey this to Greg. What's proactivity to the court?
just be creative.
Okay.
Be creative. And, you know, several weeks, come back and we can talk. But it's a privilege. It's not a right. And it's something that we take very seriously. Every single day, someone dies from a DWI in our county. Every single day. And we need to ensure that it's taken seriously, you know? I'm not asking for much. And once we know that there's appreciation, then let's talk again. Like I said, it's not long, Aaron, you know, but I need to know. Now, well, because you have a lawyer, I will waive your appearance. You do not need to waste your time coming to court, but you must stay in touch with counsel and they will tell you if and when you have to come back to court. Do not pick up any new cases. Don't consume anything illegal or any kind of alcohol, and we'll be fine. You've got a great lawyer. Listen to them. They'll take care of you. I'll have you come up here, swear test. You're not going to drive for now. We'll have you sign a reset with Victoria. We'll have you get with Fleischer for your bond conditions, and then you're free to go.
Thank you, Judge.
Thanks.
Your Honor, this is his aunt. The grandparents are outside, but she has a young toddler, so the grandparents are watching the toddler, but she knows the situation.
Hi.
She's, you know.
Hi, how you doing?
Thank you for coming.
Come on in. So I've explained to the judge his current situation with him living with the grandparents in Victoria and how you guys are supporting him. We have this time served deal that the judge is considering so that, you know, we can wrap up this case so that he can move back home, work for the family, go to school, everything that we talked about.
Yes.
He just always wants to make sure that as a young person, he has support. He knows exactly what's facing him before we do anything that he can never get back. So this plea that he wants to do, it's got its pros and cons that we talked about. So that's why the judge asked me to bring you here so that if you have anything to add or anything, so that he can consider it, so that he can make up his mind whether or not he's going to let Diego take the time served deal.
Okay.
Please, just tell me about, would he be approved for the PTI program?
He's already been approved for that, Judge. It's a 1-3. I've talked to him at length about that. It's just something that he and his family does not feel that they can accomplish with all the.
Because he can't stay clean.
I mean, Judge, I mean,
That's it.
They have some financial difficulties. So anyways,
Money is of no difference. I could care less about the money. When you take,
well, on a PTI program, Judge, I know you don't on defers and stuff like that, but on PTI, there's not a lot of wiggle room besides the $300 DA fee. I mean, that's about it. In terms of the machine, in terms of monthly, they're pretty rigid by that. So I know you feel differently and your deferred is, but PTI is just,
that's complete.
I mean, PTI is just a hard rock, Judge, especially for economical reasons. Anyway.
I know back when I was staff divisions too, like I could tell. Good on when it comes to here it is now, these.
The focus shifts to a new defendant, a 17-year-old facing a THC-related charge. The tone in the room changes instantly. What was once corrective now becomes cautionary. The judge speaks not as an enforcer, but as a mentor, emphasizing the long-term consequences of impulsive choices. The defendant's family listens in silence as the judge warns that every decision has a cost, either through discipline now or regret later. It's an intersection of youth, error, and opportunity.
I've barked up that tree many times, Judge.
Here's the thing. You're going to pay for this one way or the other. It's whether you either get this case dismissed and go through this program, or whether you take a conviction and then end up with all these surcharges from DPS, end up with a license suspension, have to pay DPS for all these other fines and fees, not to mention your insurance skyrocketing because of this DWI. Insurance rates now are absolutely bonkers because of how insurance companies are molesting us now as it is. It doesn't get better when you plead to a DWI and it goes on your record. It'll get 3 times, 4 times as worse. You're going to pay for it one way or the other. When you take a half-ass approach to something in life, you will get a half-ass result. There is a program now that you are approved to be in to get this case dismissed. All you have to do are 3 little things: a little community service, a little class, and most importantly, stay clean. That's all you got to do. And if you can do it for even 6 months, they will dismiss this case. Pleading guilty to this case, it will go on your record. It will be there for the rest of your life. It's even there after you die. And you will pay for it. I promise you. It may not be tomorrow. It may not be next week, but maybe 10 years, 15 years. You know what? Why didn't I take that class to get this thing dismissed? Ugh.
Few courtroom moments carry as much weight as this one. When the judge states that a conviction will be there for the rest of your life, even after you die, it isn't hyperbole. It's a stark truth about how legal records endure. Employment, education, housing, all of it can be affected by a single judgment. The judge's approach is direct, not cruel. His intention is to educate, not humiliate. This is justice in its most human form, firm, but deeply aware of its impact.
You're going to pay for it one way or the other. You are old enough now to make your own choices. I mean, you're what? How old is he? 18?
17.
17
in June.
Judge, I also want to correct myself. I've had him mixed up with another young client. He does need to provide mitigation information. So he's not 100% ready and approved.
Is this, what does he have now? Is it an accident?
Your Honor, it's a
THC. Yeah.
Yes, so that was a qualification.
Got it.
So I
But I mean, the odds of getting in are,
I don't want to speak for anyone, but I would assume.
I don't want you to make a decision now. But the decision you make will have lifelong consequences. And the problem is, there's only one problem, is staying clean. If I test you now, what are you going to test for? I don't want you to answer. But I think you and I both know. And it's been like this since day one. It has never stopped.
Judge, I think he's got a couple of negative tests, if I remember correct, like the last time you were here, right? I mean, he's got some negative tests and we can verify that. I mean, the last time he was here, you went down, it was negative, right?
December 12th, we had a negative, and then a no-show on January 27th.
And that's when he moved, he actually moved back to Victoria and he's back here. I mean, if you want him to think about it more time, that's great. But the problem is, Judge, he is 3 hours. The family had a hard time getting him here just this morning. So if possible, and he decides again to go down the time served, we'd really like to get it done today because that way it's just easy for them not having to come back. And that's part of the issue, Judge.
You are the master of your own domain. I'm telling you, it's the dumbest decision that you'll make now regarding your life. Because once you end up with that conviction, it will be very difficult to get a job. You will have to explain it on every single application that you apply for anything. Job, apartment, school, to get a license, to get insurance, every single application that you will apply for whatever it is in this life, you will have to sit and explain for this, and it's going to close a lot of doors. I'm telling you now that it is not a wise decision to do. I'm telling you not to do this, but if you want to, far be it from me to stand in your way. But I'm telling you, it's not a good decision.
Judge,
You guys go talk and see what you want to do.
The family.
I will give you more time if you need more time.
Absolutely.
Really. I think that you should get into this program to try to get this case dismissed. That's it. But you guys tell me what you want to do. John, if you want to do the time served, you've got my blessing, but
It's never me, Judge. I just want to make sure that the family and he understands every single word that you just echoed that I
and so much that if you go, we can allow you to report via Zoom so you don't have to come back. But you can't use. You can't smoke weed. You can't use alcohol.
But I'll also leave the operator too, to go with that, redirect you. I'll leave that operator.
I got it, Judge. But I mean, it's
You make the decision.
patient. I'm talking to him, Judge. Right. Well, Judge.
Done.
I'm covering, Lieutenant Thorne.
Oh, okay.
Then we got, Valar Judge, since he was a bond forfeiture, I've got his family and they're all gonna sit down and rethink about this, but they need some time. So it looks like, they're gonna have some hard questions to answer. So they don't mind driving back, so we should get hopefully a resolution on one way or the other, because if he wants to do the PTI route, that's got to get moving
I
ASAP.
have the indigency packet now if you want it, so that they can, if they're interested, start filling it out. And then I can.
Well, I mean, I think the way they do it now is for mitigation. I've got to put a mitigation together because he's 17, and then an application.
Then I'd like to talk to Judge Geis to see how we can. It's not fair, because, a 17-year-old doesn't have a pot to piss in. How are they going to pay for this thing? You know what I mean? So why is it fair that parents have to foot the bill for this whole thing, So we need to figure out some kind of.
No, Judge, that, usually they will waive the $300 DA fee, but machines, costs, anything, all of that, they don't even budge.
Okay.
So, I mean, whatever you can do to help the defense side on that would be wonderful, Judge. I'm pretty sure if you get a petition going, we'd all sign it.
Let me email Judge Geis. There's always a way. And I don't understand, like, the supervisory fee, why can't they be waived? It's a device that's an outside vendor.
Yeah, yeah.
And there are other vendors that will charge you a lot less,
Just so that we can reset him, so they can have time to think about it, can we just get a reset date?
But
Okay.
still needs bond conditions.
Yeah. I mean, we're all here. I mean, we could take care of that. I mean, whatever you want to do, if you want to upgrade his bond conditions from last time, because, he has.
Don't want him to smoke.
Well, Judge, the last time he was here, before he had to go back to Victoria, the proof is in the pudding. He had to make,
Is she recording? Are you recording?
Oh, that's she's with me, that's my office manager.
Oh, okay.
So, you're not supposed, please don't use your phones, Maxine, but anyway.
Don't record. All right, come up.
He does have a clear US license.
I'm gonna test him now.
Yeah.
I'm gonna test you now. The only thing I'm asking you to do is don't smoke marijuana. That's it. Do you understand?
Sir.
You don't have a license or insurance, because you need both, then don't drive as well. Don't use alcohol. That's all I'm asking you to do. I'm not asking you to split the atom or do anything funky. Do you understand?
Yes, sir.
Okay, I'm sending you for a test now. So all's clear. I'm doing backflips. I'll be very happy. You test positive, I don't know what I'm gonna do.
Okay, well, anyways, Judge, I mean, can we just get a reset till at least tomorrow or something?
I'm sending you for a test now.
Okay.
We'll give you a normal reset.
Okay.
If it's
In this courtroom, we witnessed two vastly different cases, yet both revealed the same principle. Accountability defines justice. Judge Fleischer's steady hand and unshakable tone reminded each defendant and every viewer that the law is not just punitive, it's instructive. Driving under the influence, neglecting responsibility, or taking the easy way out all lead to the same crossroad. Consequence. If you found this case as thought-provoking as we did, make sure to like, share, and subscribe to Final Word Court. Join us as we continue to explore real moments where law, morality, and humanity converge, and where every decision tells a story.